Our committee
You're
with,
now live.
we are now live. Okay, I'm going to call Senate Finance to order. Committee, we're going to have to move quickly. This is the only afternoon we can get Becky Wasserman's presence for the TIF bill, and we have other witnesses that need to be other places this afternoon. So it's a very fluid schedule. And so we're going to start with S33. We went through the bill yesterday, but so Becky is here listening in case, so she knows what we've been talking about and whether or not we need changes. So we've got Megan Sullivan on the line, and Megan, and if you need to go, because you need to leave the office where you are, just wave and come back to us when you can. But see, the concern that I have, I think, is what kind of protections are there? When you're talking about really small towns, you have 3 select board members and maybe or maybe not, you have a part-time town manager. So you have minimal amount of professional backup. And just trying to find a way, I had wondered if working with the local regional economic development authority, something, because, you know, saying if we build it, they will come is easy to do, but the marketing study would cost money. And I'm going to turn the floor over to you.
Great, thank you so much. Megan Sullivan, Executive Director of the Vermont Economic Progress Council. I completely agree and understand that. I live in a town with a 3-person select board member and a town administrator, not a town manager. So I get that having that concern that the town would be able to handle this type of tool. And we really went into this with that in mind. Is there a way to make TIF work for small communities? And if we couldn't figure out a way to do it, we would not have brought an idea forward. We think we have a good solution, and that's by simplifying the program in different ways, and making sure that the support is there in order for small communities to use this. And I think an important piece of that, jumping right in, is in the coordinating agency, which is defined in the bill. I know you went through everything with Becky yesterday, and I was able to listen to the recording of that testimony yesterday. So understand what some of the questions are and hope that I can answer them well. And the coordinating agency is going to be an organization like the Regional Planning Commission or the Regional Development Commission. Tasha Walsh has spoken in Senate Economic Development about the type of role that the Regional Planning Commission could play in really working with communities to make this type of financing work for projects, helping them through the application process and the administration process. And because of how TIF is structured, that is considered a related cost. So this isn't an unfunded mandate for our RPCs and RDCs. They're able to work that cost into their financing. And something Tasha has said is they're already involved in the planning process for some of these development projects. So, you know, what we're seeing is communities who, this isn't TIF first and then figure out the rest later. There's impetus to say, you know, there are community members, there are developers who want to do something in our designated downtown, in our village center. We know what the private development could be, and we also know what the public development that's needed to get there is, but we can't get there. Money is available to borrow. It's just the ability to repay it when you have a smaller tax base. So in this planning of these development projects, the RPCs are already.
Megan is frozen.
They already know the pieces that are
Megan, maybe if you shut off your video.
in at times.
We're doing so well. Okay,
Megan,
Oh,
do you know
sorry.
you can't be heard?
she seems to be frozen and I can't hear her.
I
So
can't hear.
maybe, is Karen here? Yeah, well, I see Karen's garden, wishful thinking.
She is frozen. Yeah.
Right. I am here, Madam Chair, and I think I'll keep the video off just in case the same thing happens to me.
Okay, and Faith, maybe you can text Megan and tell her to try coming back in, just audio or phoning in.
I did, thank you.
Okay, I should have known. All right, Karen. Do we have broadband issues? Okay,
Yeah, we do. So I just wanted to give our general support for this legislation. Again, in the Senate Economic Development Committee, they heard from towns who had specific projects in mind that they'd like to potentially get rolling with this mini tip program. One thing that I wanted to mention is that clearly you are aware that there's American Rescue Plan dollars coming to local governments all around the state, and they're not insignificant amounts of money, but their uses are going to be pretty restricted. It does include some infrastructure projects, although the only one that's actually mentioned specifically is broadband. But I think what's important about this mini TIF program is that it's something that's set up for the state and that is potentially going to last longer and has more ability for there to be professional involvement in guiding the process from regional commissions or regional development corporations than potentially with the American Rescue Plan money. So not to go completely off track, but I did want to acknowledge that those dollars are coming in. But we still, I think, need this kind of focused program for the smaller municipalities where they are able to undertake some of these projects in their village centers and smaller downtowns. I'm happy to answer questions if you like. I don't know exactly what pieces of the bill you're most concerned about. So.
other than the impact on the ed fund,
Well,
there's,
yeah,
yeah. I think
It said-
some concern, I feel better now understanding, is it required that you work with a coordinating agency?
I don't, Megan would be better able to answer that question, or possibly Senator Sirotkin.
Michael, is it?
I don't believe it's required.
I'm trying to go to the pro tem's office and I'm having a lot of problems. But yes, I don't know the answer to the question. I don't think it specifies in the bill that you're required to, but I think what we were told is that practically speaking, that would be the best resource for these small towns.
Yeah, I think a lot of
Yeah,
towns will do that.
I would feel better if we told them in consultation with, just so we make sure there is somebody, because what we've been told is there aren't enough people in this town to pay for the bond at any reasonable level. But if they build it and they don't come, then those people are going to have to pay for the bond. And I'm trying to make sure that there is a second pair of eyes on, and probably professional eyes on what, on, just on the project.
Well,
So-
Senator, you do have a large number of and varieties of municipalities who might be eligible for this. If you think about the regular TIP program, there's only, I believe, 13 of them right now. But there are a lot of other municipalities that do have professional capacity finance directors, and you would be, if you were going to bond, you will be working with the bond bank as well. I think the Development Corporation and the Regional Commission are tremendous resources that a lot of towns will take advantage of. I don't know that every town that might be interested in this would think that that was necessary. So
Okay,
I would just urge caution in that
this
regard.
just starts getting what we've been told. Westford is the example, that these
Yeah.
are really small towns that can't swing a bond on their own. And now we're hearing that Middlebury, which in my day was always seen as kind of the sister city of Montpelier, just in size and scope, which opens the possibility for a larger projects and larger amounts. Because are there 17 in or 13? There's a number of projects in 7 or 8 years. It's large for a pilot project. And could result in a good size hit to the ed fund, which in 2 years is going to be back in trouble. If nothing else, we're have to absorb a $30 million hit from the pensions. And I just want to make sure, because this seems to be kind of expanding in potential. I don't know if I'm the only one that sees that. Senator Pearson.
I don't know if we're going to have Megan back or if she can hear, but I'd like to.
Megan's
anyone hear
mute
me?
just went off, so she's here.
Okay. This is a point the chair's raised repeatedly, and I don't maybe love TIFs broadly, generally, because of some of these dynamics, but I'm really not clear why we would feel comfortable with them for bigger towns and not as is contemplated here. So Megan, can you help us understand the obligation that VEPSI has in terms of analyzing? I mean, the chair has said repeatedly, talked about this concern of a lack of a check on this, and to me that's what the role you play, but maybe I'm not understanding. Could you talk about what your process is, what your obligation is to the state, to the ed fund, to the town, and just help us understand that whether or not that is indeed much of a check?
Absolutely. Yeah, I'm happy to speak to that. And we do a great deal of work both on the application side. When a community first lets us know they're thinking about this, it's not about promoting, it's about educating, because we don't want towns to get involved with TIF, whether it's the district program or if project-based TIF was to get passed, that can't do it, that don't have private development potential. That's a key piece of this. This is not a tool for a town to just put in a wastewater system and hope that something comes of it. There have to be those communications that say that we know that there's potential for private development, and we're going to look for letters from those developers or those landowners to say, what are the potentials here? And include that. And we will look at viability in terms of what is the expected increment from this project? What is the debt service schedule? And do those things align? There is a great deal of work that goes into reviewing those financials on VEPSI side, as well as looking at the but-for statement, looking at the documentation around the but.
I think we're losing Megan
Where
again.
the communities are.
Okay, Megan, you're fading in and out.
Um, Senator, I would just, if I may, I'd just point out that the pilot in the bill allows for 15 projects, and each project's total debt ceiling cannot exceed $5 million.
million.
So those
Yep.
controls are in place already. I'm sorry that Megan, we keep
Yeah,
losing
no,
her, but
and there's a time frame on that too, right?
yes.
Was it 8 years? Something like that?
Let me find that. That's going to take me another minute.
I can just jump in and say that it should be 5 years, but the bill it has an error in it and allows for 6 years. Sorry, Becky Wasserman, Legislative Counsel. So the
Okay.
intent is that it is for 5 years.
But the potential loss to the Ed fund is $75 million. Now, remember, last year we had some issues over potential loss of $1 million to the Ed fund with a tax form. So that is the potential loss. And I lost it.
Madam Chair,
Yeah.
a year ago, we made changes to the TIF program as we already know it. And you and I might have completely traded roles in this whole discussion. So why, help me understand why you have such comfort with the larger standard TIF, but such discomfort with this small scale.
Okay.
proposal.
There have been other ways to finance projects in small communities. There used to be a federal grant for wastewater, and I believe there still is a revolving loan fund. This is the big communities are job centers. They have major economic impact in their areas. They have been suffering from urban flight and blight, and we have put a lot of money into our downtowns. We're going to be looking at the tax credit again and increasing it. I just am not I'm not sure that this year is the year to do it because there's so much money coming into towns, and we're concerned about making sure they have the technical assistance, the really little ones, so that when the money is gone, that they have something to show for it and it's not just been kind of salted away. It's a new program. It has come to us now the last week of the session. TIFs, we spent all year on writing a standard TIF legislation when we did it. This one has come to us the last week, and I'm feeling rushed. I'm not feeling comfortable that we've dotted all the I's in the T's. I'll do it. I don't think it's going to make it through. It didn't last time, but that's where we are.
Senator Cummings, this is Megan. I've called in. Hopefully that works better.
Okay, yes, we can hear you much better. Okay, I got Ruth, and then we'll go to Karen. Senator Hardy.
Yeah, thank you, Madam Chair. I mean, I'm the new girl on the committee, and I don't know a ton about TIFs, but I'm very reluctant about them. What I do know about them, even standard TIFs, and I'm sorry that Senator Sorokin's not here because isn't he the TIF czar or something like that?
Actually, I am.
Oh, you are? Okay. He's the TIF king. Anyway, and so I share your concerns, Madam Chair, and given that you have been supportive of TIFs in the past and are now reluctant, that makes me even more reluctant. And hearing $75 million to the Ed Fund is concerning to me. And given that we have all this money coming into municipalities from the federal government, I also question whether this is the right time for this. So, you know, I could be convinced otherwise. I was waiting to get more information. Whoever did the flow chart, I think it was Megan. Thank you for that flow chart. It is on our website. It's very nice. I appreciate that. And it does help me understand the process more. But I'm reluctant too. So unless I hear something that really convinces me that we should do this, I share the chair's concerns.
I think what I'm going to do is move us on. We've got Friday and I think a fair portion of Thursday. Today is the day we're really packed. We put this on because Becky could be here. But I got two other ledge councils who have timeframes, and the other bills I'm hoping will be fast. I did see Judge Grierson pop up. So I'm going to put this off. Megan, I hope you can join us, and Karen again, and I hope we'll have Senator Sorokin free. And if we can't finish it up, then we can ask for an extension and take the time to work on it. And see
I'm
where
so sorry for my connection problems today. If there's some additional information that I can send to the committee, I know this is rushed, so as much information as I can provide you in between meetings so that you can become more familiar, I will do that. I don't want to bombard you, but want to make sure that you have the opportunity to really look at everything we have. We have sort of a draft application that we put together, and as well as, you know, a one-pager with the infographics of how it would work. So we'll make sure that the committee has that today, so you have time to process it, and gave some information of some others, folks that I think would be helpful in testifying, that would, you know, add value to the conversation.
Okay, I think it might be helpful if if you could send us a list of some of the possible projects. I think the only one we've heard that was last year, and that was Westford. But maybe to give us an idea of some of the
Absolutely.
potential projects that are out there would help us understand this. Okay.
I'd be happy to do that. Yep.
Okay, good. Well, with that, I'm going to move us on. Thank you, Karen and Becky. I'm going to move us. Where am I? Yeah, to our 215. This is S97, and I see Judge Grierson is here. I'm looking for Eric Fitzpatrick.
I've just sent him a note, Senator Cummings. He should be
Okay,
here shortly.
This is this week. So committee, anybody else you would like, just send me an email for anyone else or questions you'd like answered on the TIF bill. And Michael, we've got all kinds of staff availability issues, so we're going on. And on this screen, I don't have the Thursday, just today's agenda, but we're going to put the TIFs back on, and I know Friday is pretty empty, so we'll see if we can get it out.
Okay, I am waiting for a day now to get an answer from Bloomer as to whether it has to go to appropriations. He said he didn't know yet, so I just wrote him again. So we'll see. I'll let you know as soon as I know.
Well, if it came over sooner, we could get it done.
We all have those problems.
I know. Okay, Eric, you're here. And
Yes.
we're on, I think, S97, which is miscellaneous judiciary procedures. So walk us through why it's here. What
Sure.
what does that bill have to do with finance?
Well, that's a very relevant question. This is Eric Fitzpatrick with the Office of Legislative Counsel. Good afternoon, everybody. Here, as the chair mentioned, to talk about Senate Bill number 97, which is the annual Miscellaneous Judiciary Procedures Act. I believe that's here because there are two fees in the bill related to the probate division of the Superior Court. They're related to two topics, which I'll actually, I should probably ask Senator Cummings, do folks have the language in front of them, or probably isn't that necessary?
It's posted, so yes, if they can get it, or you can
Okay.
put it up.
Right.
But for this one, it's probably, we probably don't need all the language, just explain what the fees are.
Sure, makes sense. So there's two different probate division related fees that are in S97. One of them relates to what's known as wrongful death actions. And the wrongful death action is an action that is brought for damages on behalf of a person who has died. You think of the way the civil court system works. Ordinarily, when a person is injured, sustained some kind of damage, could be property damage, could be injury to the person, they couldn't bring a lawsuit for negligence or something else in the Superior Court for damages. But a wrongful death is a particular kind of action that is available when, not having just been injured, a person actually has died. They've been killed because of the wrongful act of another person. And all states, all 50 states, and actually many common law jurisdictions throughout the world have wrongful death statutes. They came about, it's probably more history than you're really interested in. It's semi-interesting from my perspective, but historically, the common law courts mostly ruled that the sort of a Latin phrase that I learned in law school, many people, maybe other did as well, that a personal injury dies with the person, so that they did not permit someone to bring an action for damages if the person had died, because there was no plaintiff, no person to come into court and say, I'm the one who's been injured, because the person has passed away. So legislatures passed these wrongful death statutes, and those statutes permit, they essentially overruled this common law rule to permit an action to be brought on behalf of the person who has died. And in that case, though, and the Vermont statute is very similar to all the others throughout the country, it's required that the court has to appoint a person to represent the person who has passed. And that person is called the personal representative. There's a representative who has to bring the action in the name of the decedent, the person who's died. And typically that person is representing the estate. That's why you see these, this comes up in the probate context. This person is bringing an action on behalf of the estate of the person who allegedly has died because of some wrongful act of somebody else, whether it be negligence or whatever. So the statute that we have on the books now in Title 14 requires that this personal representative be appointed to represent the estate, but there's no fee attached to this procedure that the probate division has to appoint somebody that has to be clearly documented in the case, and has to handle all the procedural actions in the case going forward. And so the probate divisions, I think, have been, from Judge Gerson might be able to provide a little more detail on this, but my understanding is that there has been a lack of clarity amongst the court as to what the fee should be, because it's not specified in statute. So it is specified and so the request came from the court that there has been this some differences in practice between the different probate divisions in the state as to what the fee should be. Some were thinking that maybe it would be a percentage of the recovery. You know, for example, if that wrongful action is successful and there's a recovery, some thought that that's what it ought to be. But I think that the conclusion was that it should be the similar to the least amount that is required for currently, under current statute, the filing fee for the opening of a probate estate for I say the least amount, the probate fees for probate estates vary based on the amount of money in the estate. So the smallest one, $10,000 or less, is a $50 fee. So that was the conclusion, was that would be the appropriate fee, particularly because if there is a successful recovery in this wrongful death case, at this stage of the game, when they're just appointing the representative, no one knows how much it's going to be. Could be a little bit, could be a lot, no one knows. So they decided that it made the most sense to set the fee at $50, which, as I said, is the lowest amount currently on the books for opening an estate. So that's one of the fees. Sets the fee for the appointment of the representative in a wrongful death action in the probate division at $50.
Okay, any questions at this point? Senator Hardy.
Thank you, Eric. I'm just looking at the language in the bill. It's on page 6, I think. Is that right? And it sort of ties it to the lowest fee. So it doesn't say it's $50. It just references the section in the statute. So if the fee for estates of $10,000 or less was increased, this fee would also automatically increase. Is that correct?
That's exactly right. Yeah.
Okay.
And if you look, you may have noticed this already, Senator Hardy, but if you look right there where you were at the new language in subsection F on page 6, it cross-references, as you mentioned, the current $50, and that appears several lines below on line 20 to indicate that the current fee for that lowest size probate estate is $50, just so it's sort of there visually. But as you mentioned, if the legislature ever decided to up that fee a little bit, then yes, the personal representative fee would go up correspondingly.
Okay, great. Thank you.
Yep.
Any other questions? Okay, Eric, we're on a roll.
Okay. The second fee, probate division related fee, which you'll see is actually, if you happen to be looking at the language, it's just the top line on the next page, on page 7, at least on my version of the document. And this has to do with registrations of guardianships in Vermont that have been established by courts in other jurisdictions. So this has already been going on, and there's some, under certain circumstances, a legal requirement that it does happen. So in other words, you got a situation in which a guardianship has not been set up by order of a Vermont probate court, but has been set up by, just to use an example, of, say, a probate court in the state of New York or New Hampshire or some other state. But the person who is under guardianship might well be in Vermont, and therefore the order establishing the guardianship that was issued by, a Superior Court in New Hampshire or New York is registered with the probate division in New York, so that there is a record that this guardianship exists. In addition, the Vermont guardianship laws require quite a number of procedures related to guardianships, that the accountings have to be filed every year so that there's a record of expenses that have been filed, that sort of thing. So to the extent that any of those documents are ever, copies of them are ever filed in Vermont for an out-of-state guardianship, there needs to be a record that this guardianship exists, because the what used to be called the ward now is called the person under guardianship. But that person who is subject to the guardianship order may be domiciled or live part-time in Vermont. And so there's a reason that in a particular case that sometimes these courts from other states file the copies of the guardianship orders with Vermont probate courts. Again, there's a lack of clarity about what the fee is for the registration of that order. And I should say that I know when you saw it uses the word foreign, but it means any other jurisdiction. It doesn't necessarily mean a jurisdiction that's out of the United States. It could be, but a foreign jurisdiction also could be New Hampshire, any jurisdiction that's not Vermont. So again, clarifies the filing fee that was unclear in current statute, but the orders themselves have been filed and have been registered. The practice has been going on. It's just that there was a lack of certainty, lack of clarity among the probate courts about what fee they ought to be charging for the registration. So again, this was a proposal from the court. They were all on board with choosing this amount, the $90, and the Judiciary Committee agreed with that, and that's why it's in S97.
Okay. Any questions?
I have one more question.
Ed Hardy.
Sorry, Madam Chair. The $90, is that consistent with other similar fees for this type of thing?
Yes, I was just going to pull that up.
Yes.
The guardianship. And the
I
answer
just
is
don't have any idea what the sort of scale is for judiciary fees. So just if the $90 is based on something similar, that's good.
yeah, I see Judge Grierson. I might defer to the judge on this one, just because that was a particular question that I posed to him earlier this afternoon as well. So I think he might have some information for you.
Judge Grierson, welcome. Can you enlighten us?
Well, I will try. I'll let you be the judge whether I actually enlighten you or not. Thank you, Madam Chair, and the committee for inviting me to testify on S97. For the record, Brian Grierson, Chief Superior Judge. Going to the latter question by Senator Hardy, this is a provision that came into effect, I want to say 2017. I'm not sure of the date, but Old H290 Act 24 provided for the filing of what are referred to as Eric said, and he's done a good job describing both these proposals. Filing a foreign order, in other words, an order from another state for where someone was appointed as a guardian, but they have property in Vermont that needs to be addressed by the out-of-state guardian. And so the bill came into effect, or the authority to do it, but it didn't attach a fee to it. So the judiciary adopted the fee of $90 because there was the same fee was applied to the registering of a foreign child custody order in the family division. So we were looking for something that was akin to the filing of a document for registration, which is fairly common in the family division, but perhaps not so much in the probate division. But that's the basis for the fee. There was one that was similar, and we adopted it in the absence of any other direction from the legislature. So what we're trying to do here is to codify what has been the practice on that issue. If there are no other questions on that point, I can go back quickly to the other fee.
Any questions? Okay.
On the other one, it's pretty straightforward. As Eric pointed out, the proposal is to adopt a fee of essentially $50 fee, which is essentially the small estates fee. The reason for that is these filings can come about at two different phases of a wrongful death action. If someone applies to the probate court early on in the process, they will not have any idea what the value of the estate was. And if you look at Title 14, I think it is, I'm sorry, 32, 43, 34 spells out the various fees, but they depend on the size of the estate. And obviously they get progressively higher. So if someone files at the beginning of an action, they have no idea what the value of the wrongful death settlement will be. So the probate courts have been assessing the smallest fee, $50, for estates less than $10,000. In some other situations, attorneys have come in essentially at the end of the process when they've achieved a settlement and they're looking for the appointment of a personal representative to administer the estate. And there's nothing wrong in approaching it either way, but the difference was that some probate judges were then looking at those cases at the end of the process of saying, well, we're going to assess a fee based on the size of the settlement. So there were inconsistent fees being assessed by the various probate courts. So we took this issue to we have a standing oversight committee for each of our divisions, family, criminal, civil, and probate. Took it to the probate oversight committee, explained the issue, and certainly got a consensus from that committee, and they reached out to the probate judges. I cannot tell you that every single probate judge agrees with this, but the consensus has been that we need consistency. It's not fair to litigants to have a different fee around the state. And so the proposal is that we accept the fee regardless of when the petition is filed, to assess a fee of $50 as the smallest, the nominal fee. But that's the basis for this request. And again, much like the other request, it's to provide some consistency across the board, across the state.
Okay. Any further questions? Any further discussion? Would anyone like to make a motion?
I'll make the motion since I'm the one that asked all the questions. I move that we accept, what is the motion? S97 as sent to us
Vote.
by the Judiciary
Yeah,
Committee?
I think we just vote to approve.
Okay. So I move that. Oh,
Okay. Senator Pearson, you have a question?
Yeah,
Madam Chair, we're
do we need to understand the total this fee raises? I didn't think I heard that.
You know, if that's for me, I tried to get a information from our staff as to how many of these are filed, and I was not able to get that information except anecdotally. Very few of the guardianships and not that many wrongful death actions. I mean, it's a relatively small number. It is not a large fee generator in either case. At least that's what I've been told.
Thank you.
Madam Chair.
Yes, Senator McDonald.
So
yeah.
my role as clerk, we're moving to concur with S97 as it came to us.
Yes.
Thank you very much, Senator Hardy.
Okay. Is there further discussion? If not, all those in favor say aye.
aye.
Opposed? Hearing no nays, that is, we approve 700.
We
There are-
have 7 people here.
No, we don't. Senator Sirotkin is, well, his name's here, but not his picture, so he can't vote. So it's 601.
Thank you, Madam Chair.
701, I'm here.
He's
just-
there. He's miraculously appeared.
Thank you, Senator Sirotkin.
I offer to report the bill too if you want.
Oh, okay. That saves that next discussion. Thank you.
And finally, Madam Chair, we were sent the original bill or the bill as amended by
Eric?
I believe I sent the amended bill, the strike all amendment that Senate Judiciary voted.
Thank you.
You bet.
Okay, bill is
This
amended.
Zoom business is, thank you for straightening that out.
You
Okay.
bet.
Okay, thank you. One down.
Thanks,
Thank you.
everybody.
Thank
And
you,
I
Madam
think
Chair.
we're actually back on schedule. Actually, we're 5 minutes ahead. But it may take that much time to get Michael O'Grady in. Oh, and this is the chicken bill.
Senator Cummings, we're switching S102 with
Ah.
S101 and Ellen has joined us.
And Ellen is here. Okay. All right. Thank you. So we'll go, yeah, now we're really ahead. So Ellen, walk us through this one. This is S101, an act relating to promoting housing choice and opportunity in smart growth areas. And Senator Sirotkin, this is an economic development bill. Do you want to tell us what it does?
Yes, this is a successor bill to S237, which passed last year out of our committee, went to natural resources, passed out of there with certain changes. I think the sections that survived out of natural resources passed over to the House. Chris could recall, but I think unanimously. And then in the House, they ran into some more difficulties with Act 250 and land use things. So several provisions that we had in our downtown bylaw development bill might not make it all the way through the process, and we consolidated them. As you can see, I think in the first page of the bill, there's 4 or 5 bullet points that summarizes the bill very nicely. And
Is this the bill that got conflated with the Act 250 changes? It ended up, or one of them ended up back in finance.
Did it? Yeah, I learned my lesson to stay away from Act 250 politics.
Probably a good lesson to know. Okay. So Ellen, can you screen share and just walk us through tell us first, why is it here?
They're because of the tax credits, I think.
Okay, that's
Just
probably
going up 1.75 million or 1.75.
This is what was proposed last year, right?
No, we had proposed a smaller number. This new number is from the governor's office. It's in his budget package, I think, as well.
Okay. Okay, so give us a 10,000 foot walkthrough, Ellen.
Sure. Ellen Tchaikovsky, Office of Legislative Counsel. Can you see S101 as introduced?
Yes.
Okay. So S101 is introduced, primarily does 4 things. It establishes this new type of grant within the municipal and regional planning grant program. So it establishes this new specific grant within that program to give municipalities funds to modernize their existing bylaws to accomplish the goals of promoting housing choice and additional housing opportunity in smart growth areas. And there is an appropriation associated with that. There's also an appropriation to the Department of Housing and Community Development to assist developers in navigating the permitting process, specifically related to infill housing and accessory dwelling units. Then there is the section about downtown and village tax, the downtown and village center tax credit program, which I think we're going to spend our time right now talking about. And then there's also a section at the end that the Natural Resources Committee is currently working on related to municipal and state wastewater permits. Currently, there's a permit issued by the municipality in addition to the permit issued by the state. So there's a section allowing municipalities to be the only entity to issue those permits.
These are hookup, right? Not the development of the plant, but the hookup. Yeah, I've been trying to get rid of that for 40 years.
Which one, Madam Chair?
The dual hookup fees. Jeff Winberg tried too. We haven't succeeded yet. It's a thing with mayors.
Which one are you trying to get rid of, Madam Chair?
Right now, the hookup. The city gives you a
the
permit
town
that
fee or the
says
state fee?
the state fee, because the state, it's the town that says they have the capacity to hook you up to their wastewater plant and their drinking water. I think it's just wastewater. And sometimes, and the state shows up and the state stands there. So anyway, that's not in this bill. We're not dealing with that, Senator.
It's in this bill.
I know. Was last year.
So I just wanted to flag, I don't want to interrupt, but we didn't take this bill. We just did a look at the bill because of the wastewater, potable water aspects and natural. We're still taking testimony and working on a modest amendment to try to work out a few kinks in terms of how that relationship would work. But I just wanted to flag that if the state stops issuing these permits, there's a loss of revenue to the state, and it's hard to see when you're looking at this. And so I just wanted to flag it because it was a significant number, like I think well over $100,000 when we got a ballpark last year in earlier discussions. So I just didn't want us to not notice it's kind of invisible in here.
It is, but that's also an increased cost to develop. So if you're trying to develop affordable housing, that's just one more cost.
Yeah, I'm not opining either way. I'm just saying
no.
It's hard to see because it's not mentioned, but if we change, then there's loss of revenue to this.
Do we have a fiscal note on it or not?
We don't. No.
I don't think so. No, and I think that's a good point, because I was curious if you were interested in hearing about that section. And also just to point out, so the first part about the Municipal and Regional Planning Grant Fund, so that fund is currently funded by the property transfer tax. And so this is adding a new type of grant to that program, but it is being supported by an appropriation in here. So I didn't know if you wanted to review that language also.
Now, if it's an appropriations, approps will review that.
Okay. So otherwise, I'll take you down to the tax credit language, which starts at the bottom of page 5, but really on page 6. And you have already discussed this in your committee a little bit this session, I believe. So the Downtown and Village Center Tax Credit Program. So currently there's this program, I think you heard about it earlier this session. It currently applies to qualified buildings located within a downtown or village center. And to qualify as a building, it needs to be at least 30 years old, and it needs to be an income producing building. So, and then there are 3 types of tax credits within this program. But this is just adding that buildings located within neighborhood development areas will now also qualify for the tax credits. And section 6 raises the current cap. There's an annual cap on the program. The current cap was added back in October. It's $3 million, and this proposes to raise it to $4.75 million.
Okay, so that's a 1.75 loss in revenue. And what was it before October?
It was 2.6 million.
That's what I thought. So because we didn't do one last spring when the bottom was falling out, but I thought we had done a pretty significant one. All right. And this would be 1.75. Do we have we've upped this almost annually, at least every 2 years. It would be interesting to see a chart. And
I have it if you would like that data. So the program was created in 2005. And it went into effect in 2006, and the initial cap was $1.5 million. In 2007, it was raised to $1.6 million. In 2009, it was raised to $1.7 million. Then there was a 5-year gap, and so in 2014, it was raised to $2.2 million. Then in 2017, it was raised to $2.4 million. Then in 2019, it was raised to 2.6 million. And now we're at 3 million. So this would be the largest increase by a pretty fair margin. But the program is 15 years old and it has been increased 5 times already, 6 times already.
What we heard was that it's taken up as fast as we put it out there. And this is the one that there were, okay, there's limited things this one can be used for, right? Is this the one we talked about, facades?
Yep.
So
Yeah, within the program, there are 3 specific types of tax credit. There's the facade improvement, so the exterior of the building. Then there's also historic restoration projects that can be used, and then also code improvement, a tax credit for the code improvement. So things like an elevator.
Okay, that was an elevator, because that's the biggest issue in my experience with doing second floors, is ADA codes and accessibility. Those old staircases are built like ladders. So, okay, they can be used for elevators. All right. And the neighborhoods. The downtown tax credit can be used for designated neighborhoods. And I remember when we did the neighborhoods, I'm not sure how this, are we talking a neighborhood, like an historic neighborhood that's contiguous to downtown? Because the last one we were talking about was new development.
Yes. So in general, the tax credits can only be used on a building that's at least 30 years old. But yes, the designated neighborhood areas are the neighborhoods directly around either the downtown village center or Newtown Center. I'm hesitant to use the word historic because I'm not sure that's actually technically required, but they are the areas immediately surrounding the commercial core.
They're not new neighborhoods. There is another bill we did a number of years ago that was new neighborhoods. It was under the Douglas administration. Okay. Okay, questions at this point, committee?
Ellen, can you just scroll down a little bit? Or yeah, scroll down. So why are we taking?
What are we striking out here?
Oh, sure. So there's 3 sections within this section that are sort of technical corrections. So this is the requirements for a village center. So under the village center statute, it lists the incentives and benefits. And currently in the statute, it lists the 3 individual tax credits. And so this language is just replaced by the title of the program overall. Okay. And it does that also for the neighborhood development areas and the downtown statute so that they all match and just reference this uniform program.
Okay.
So there's the expansion of the breadth of the program in this bill. Is that not correct?
Yeah. Yep.
So that's one of the things that I was concerned about, Madam Chair, that if we were going to go ahead and expand the areas that are eligible for these credits, we needed more money, and the governor and his budget agreed with that. So we're doing 2 things. We're expanding a program that has a significant waiting list that's been proved very effective, and also expanding the area of.
Okay. Okay, so we're expanding it into neighborhoods, and we're expanding the money by the largest jump we've ever done.
Madam Chair?
Yes, Senator Hardy.
Thanks. So the towns that are, or municipalities that are eligible for this, I understand that there's a certain type of building or project that's eligible, but as it relates to the last bill we tried to talk about and then aborted with, is there a size to a town? Can any size town qualify for this as long as they have a project that is
I think they have to be a designated downtown. So there's all kinds of rules to get the designation, but I think Ellen could answer it better than I could.
Right. So these tax credits are available to designated centers. So towns that have a designated downtown or a designated village center. And then this is proposing also for designated neighborhood development areas. So the town does have to achieve the designation. And currently there are only 7 that have already done that. I think there was testimony in the other committee that there are other towns that are currently in the process of applying for the designation. And so, yes, there are currently only 7 towns that would be eligible if this expansion passed.
only 7 towns? And we're putting this much more money into it? Are we not putting money into it so that more towns can be eligible? Or is it just those 7 towns will be eligible for higher amounts?
Well, we're expanding it to neighborhood areas. I'm actually, I mean, the person who could really fill us in on all these details is Chris Cochran. And I'm having a little trouble with the number 7 because I keep seeing all these glossy brochures of this program, and they show little general stores in areas that I can't imagine they're one of 7, but I could be wrong.
So, and this is only for designated downtowns, not, but because I heard something about village centers and new town centers.
Right. So the existing program for the tax credits, downtowns and village centers can apply.
Yeah.
So in the
But
designation,
there's only 7?
no, I'm sorry if I've confused this. So
Okay.
in the state designation program, there are 3 core designations: downtowns, village centers, and new town centers. Then there are 2 add-on designations that a town that has achieved one of those 3 can then apply for: neighborhood development areas and growth centers. So in order to get a neighborhood development area, you have to already have one of the downtown, village center, or new town centers. So there are many more towns that potentially could be adding a neighborhood development area. There are, I believe, 186 village centers, and there are 23 downtowns. So there are a lot of other towns that are potentially eligible under this program, but currently there are only 7 neighborhood development areas.
Okay, so the thing that's throwing me is we're talking about neighborhoods around the town. We're talking about, the buildings have to be 30 years old. We're talking about facades and historic preservation, and code enforcement is pretty broad. It's development. Most of the, is the purpose, because the neighborhood areas I remember were to develop new housing and new neighborhoods. And I think that's where I'm getting confused is I'm thinking Liberty Street or the Meadows in Montpelier. They're very distinct neighborhoods. College Street. Some of them have bigger houses with columns, and some of them are small. We called them shoe factory houses when I lived in one, but they were basically smaller homes for workers in neighborhoods. Okay. So this could be used to spiff up the facades to help some of those homes come up to code. Anything in here about weatherization?
No. Not directly.
Would weatherization, I guess it's not into the code yet, though, is it?
Are you talking about like the regular residential or commercial building energy codes?
Well, I know we did with new building codes. I'm just wondering if you're rehabbing, I mean, in Montpelier, when we did the sprinkler ordinance, which we have fortunately gotten rid of, if you did any major internal changes, you had to install sprinklers, which in a house that's over 100 years old was very expensive and probably stopped some redevelopment. But I'm just wondering, since we're trying to get everybody weatherized, and here we're talking about qualified codes, why not put weatherization in there?
Madam Chair.
Yeah.
When we think of weatherization, it's usually a retrofit. And I'm not aware of any code change that has people going back.
Right.
So new builds have all sorts of energy code, including insulation standards. But so I don't know if that helps clarify, but I don't think.
No, I don't think it's a code. But I'm just wondering if we're making tax credits available, because the tax credits don't go to the community, right? They go to a developer.
Right, but they're developing, and typically either a retrofit or a new building is going to have to comply to code, and code has good energy standards, as I understand it.
Okay, I know we adjusted the residential building standards. So this has to be income producing property.
Yes.
So it would leave out private homes.
Correct.
Which might mean, I don't know if Barry Street's in the designated downtown.
I think Berry Street actually is.
I think it might be, but
yes.
I know it's in the design review district, and I know the Econo Lodge is in the design review district, but and I know we had zoning lines that were splitting houses at one point, but Senator Sorokin, well, maybe we need Chris Corcoran, but I'm trying to understand. This sounds like originally this was set up to help more historic downtowns and I remember the pictures because there was some concern about facades and what a difference it made to the property to just replace the rotting paint and cornices and other things. What I'm not clear about is how that, unless there's different standards for a neighborhood, because a neighborhood, I suppose an apartment building is income producing.
Right.
And a corner store, but privately owned homes, which are the bulk of many neighborhoods, unless we're aiming at some of the abandoned buildings in a couple of I know Rutland and Barry both have issues with buildings that need a significant amount of rehab. So maybe we need to get Chris Corcoran in.
Yeah, I would encourage that. He is Mr. Downtown Tax Credits, and he's very good.
Oh, I know.
He knows the insides and outsides. So instead of us flailing around on some of these questions, I think I know the answers to some of them, but it'd be better to have him come in. And the other possibility would be the pro tem who's reporting this bill, who's across the hall right now. She might have more details on it, but I think it's the kinds of things you could use the program for is more uniform, but the criteria to get into the program now, like now neighborhood development areas would be allowed to access these credits where they weren't before. But I know it's a very popular and it leverages a lot of other monies, and Chris would be great. I bet you we just need him for 5 to 10 minutes.
Faith has emailed him.
Okay.
So,
Madam Chair.
Yes.
I also just want to remind the committee that we got at the beginning of the year a presentation from Graham Campbell in the tax expenditure report about this program. And I'm just looking at it now. I strangely still had it open on one of my tabs. That's how many tabs I have open. And he does actually, JFO highlighted 3 minor areas for legislators to consider on this program. And I don't know if they're considered in the bill, but his report is good and it's mostly positive, except for these 3 minor suggestions that he makes.
Right, and we'll have him back because
overall, I feel more comfortable with this than the TIF thing, just because we've actually talked about it before in this committee.
No, it's the large increase to 475,000. I don't think Graham knew about that one.
4.75 million. That's a big increase.
That's a big increase. And then I'm just curious as to what the concept of neighborhood is and how, if this is going, why they think this is going to help with just what's it going to do. So maybe what we'll do, Ellen, that's the bulk of what we have to do with this, right? Is that increase to the tax credit?
Yeah, I think this is the only section in the bill related to your area. I mean,
okay.
Not the loss of the fee?
What?
Not the loss of the fee? That's not.
We've never done that. We can ask Graham to talk to us about that too. Okay, Senator Pearson.
I wonder if I could ask Senator Sorokin, if I recall that this tax credit's been critical for affordable housing developers. And am I right or wrong about that?
There's another tax credit, I think, that goes for housing.
It's a different tax credit that goes for housing, but they do access this one as well.
This is when they're doing multi-use buildings.
Yeah, I think they maybe have used these for like elevators and things like that. Again, I would defer to Chris Cochran on it.
Sprinklers.
Okay, thank you.
And that would be a question. This is a huge increase, and it does code and it does elevators and facades. Ellen, I doubt but what's the housing tax credit for right now? Do you know how much that is? Because that seems to be the critical need. No, okay.
I don't know, sorry.
Okay, I don't either, but I'm pretty sure it's not at 475. I believe we upped that last year. And I think they've always been kind of the same, in that kind of a balance, but we will check on that. So we need to ask joint fiscal for a fiscal note and ask them to throw in the loss of revenue on if we do away with the state hookup fee. And then whenever we can get Chris Corcoran, and we'll try and get him back maybe later today. Okay, does that work? Anything else we need to know? Any questions? Senator McDonald.
Madam Chair, I like most of this bill, and I particularly the tax credits in villages in small towns where the persons or the entity taking the tax credit can sort of gives them a chance to invest some of their invest in their own communities and solves a lot of problems. Senator Bray was talking earlier about the elimination of the fee for hooking up, and that is we were taking testimony in Natural Resources this morning, and we're finding that the fee that the state collects to hook up, that in more than a couple dozen municipalities, they're hooking up to systems that are driving without a license. And when we ask how come the systems aren't, their licenses have expired and they're, excuse me. I have my computer on top of the microwave and I just turned it on. Things are heating up, Madam Chair. So
they melt.
We're in a bizarre situation of not being able to help finance the upgrading of stormwater issues. We're cutting revenues to the agency of government which is charged with dealing with stormwater bypassing and sewage issues. And by taking the state out of it, we have the regulators, the state, and now presumably we're going to turn these decisions over to the communities, the local communities, to hook up to plants that are not licensed. Licenses have expired, that we are not making any major advances on cutting the problems that exist. It's sort of ironic that and furthermore, when towns, and I know this is a bit out of our jurisdiction, Madam Chair, when municipalities go and seek relicensure when their licenses have expired, they hold public hearings. So the public doesn't get a chance to go in and complain about the various pollution that's taken place because the public hearings don't take place. And when we remove the Act 250 from the mix, the Act 250 is yet a second place where the public has an opportunity to come in and say, why are you doing X, Y, and Z for wastewater treatment plants that are failing and haven't been relicensed? So the public once again loses an opportunity to come in and speak on local issues, which means that the legislature sort of is left with this problem, and we're getting more and more polluted waters rather than less polluted waters. So maybe that's what the Chair of Natural Resources was trying to question earlier on. And this is not this committee's jurisdiction. But if we're going to approve these things, we ought to know what the heck we're doing, and the benefits that may accrue from the bill before us also have some shortcomings that we are, as a legislature, are for one reason or another not tackling. Thank you for allowing me to share that.
Senator, that was somewhat, my objection is to charging a person trying to hook their home up to the town sewer to pay twice for the same service. It sounds like the state has definitely a problem if we've got a whole bunch of wastewater plants running with expired licenses. I would suggest we probably need to put some more money in there, but you're not generating enough money, and you're just double charging a project
That's
for the
correct.
same service.
Or you're charging them in two different places for half the service, but that's, you know, that's also correct, but that's smart aleck math. So-
Yes, it is. That's
So,
worthy of an 8th grader. Okay, we do not have time
Guilty.
for smart aleck math.
So thank you for letting me share the bigger picture, and I understand your concerns, as I hope you would understand the concerns of the Chair of Natural Resources.
I understand that it's hard to give up money. We're being asked to give up a lot of money in this
Madam
bill.
Chair, it's the driving without a license that's the problem.
That is the problem. You're not solving it by charging people twice to hook up. Okay, Senator Bray, I'm going to get off of this subject because it's not in our jurisdiction.
Okay. All I was going
And-
to say was something reassuring, but I'll keep it to
Good.
myself.
If I can find my agenda. Okay, so that one,
Senator Cummings, we have Michael O'Grady coming at 3:30 for S102
okay, so, and then David Hall.
at 4 o'clock for S79. And
Okay,
you're
so
on break.
then we've got, okay, we can take a whole 15-minute break. Does that work? Shut off your audio and video.
Ending live